Hello.
Hi, good evening, sir.
Good evening. How are you?
Fine, thank you, sir.
Yes, we are taking two papers today.
Yes, sir. Group 6 and 7.
Are they ready?
I believe they are, sir.
Group 6. What is
Yes,
the title of their
yes,
paper?
Prof. Good evening, Prof.
What is the title of your paper?
Exclusion of otherwise applicable foreign law.
Okay.
Exclusion
That's a
of otherwise
straightforward paper.
applicable foreign law.
Yes. We give you 30 minutes.
Okay,
Who are
Prof.
the group members?
Okay, we have
Who are the group members?
please, are we?
And are
Aládétìmẹ́yìn
they
pẹ̀lú mi.
present?
Ọlákànmí Ọmọyẹni. Ojo Florence Amonisola Ayinde. Please, are we all here?
Class governor, please take note whether
Yes,
they are
we are.
present or not.
Toluwani Ojo is
Toluwani
Okay,
is
sir.
here. Omoyeni is here.
Olakomi Omoyeni is there, sir.
So we are still waiting for Pelumi Amonisola.
Okay, class governor, please take note.
Yes, sir.
Okay. Who is presenting?
I'm starting with the chapter 1. Why Toluwani will take the chapter 2, and Monisola or what's it? Yeni, we take the chapter 3 and 4.
See, we don't have all that time. There are 4 grounds of excluding otherwise applicable foreign law. Spend some 5, maximum 7.5 minutes to talk to each
All right,
one of them.
we'll just summarize it. Awesome.
Yes.
All right.
First, tell us what are the 4 grounds.
Okay.
Okay. Then take some 5 minutes to talk to each of the 4 grounds. Citing cases for us. It's a straightforward topic.
Okay.
So please start.
Okay, Professor, I should not go into the introduction and abstract to chapter 1.
We don't have that time. Time is against us.
Okay.
What are the grounds for excluding otherwise applicable foreign law?
Okay. We have the grounds for exclusion. We have 5 grounds here. We have pleading and proving.
Yes.
We have foreign revenue laws in the conflict of laws.
Yes.
We have foreign penal laws.
Yes.
We have public policy and conflict justice.
Okay. Well, which one is conflict justice? Are you talking about relativity? Okay, let's see the way you have presented it.
Okay, sir.
Okay. What does it mean when you say you are excluding otherwise applicable foreign law? What do we mean when we say we are excluding otherwise applicable foreign law? Explain to us from your lecture.
Okay. All right, sir.
What does it mean to say you are excluding otherwise applicable foreign law?
Okay, sir. So we said the exclusion of foreign laws occur in specific circumstances. After a court has assumed jurisdiction over a case and determined, based on the applicable choice of laws, that a foreign law should govern the matter, it may nonetheless decline to apply that foreign law. This exclusion is typically justified by certain considerations, such as public policy conflicts, the foreign law's incompatibility with fundamental principle of justice, or when the foreign law's application will undermine the sovereignty or legal integrity of the forum. The court will refuse to apply that foreign law for one or more of the following reasons. So we have the pleading and proving. Pleading and proving outlines the specific claims a party brings before the court. In legal proceedings, foreign laws are treated as matter of fact. Therefore, in addition to including a foreign law in the pleadings, a party must substantiate its true appropriate proof. Failing to establish a foreign law has the same legal implication as omitting it entirely from the pleadings. This principle was emphasized in Reduke of Wellington, where the court affirmed that English law would be applicable by default unless a foreign law is both plead and proven. Similarly, in aluminium industry versus Romfa Aluminium Limited. The English court applied English law to the contract, despite the clause stipulating that Dutch law will govern the contract. The parties' failure to prove and prove Dutch law led to this outcome. Foreign law can be established through expert testimony as provided under Section 68 and 69 of the Nigeria Evidence Act 2011. Court may also utilize statutory and judicial tools to interpret ambiguous expert evidence effectively. The testimony of experts is crucial in helping the court understand the foreign law in question. Also in Section 4, Sub 2 of the English Civil Act of 1972 allows a prior judicial decision that applied the foreign law to be admissible as evidence in a subsequent case involving the case foreign law. Although Nigerian law lacks an identical statutory provision, the doctrine of judicial precedent ensures that previous decisions interpreting foreign law serve as persuasive evidence, especially in lower courts. This principle was illustrated in Phoenix Marine versus China Ocean Shipping Company, where judicial precedent played a pivotal role. Also, an distinction must be made between foreign law and the laws of other Nigerian states. Section 122 sub 1 and 2 of the Nigeria Evidence Act 2011 stipulates that courts in Nigeria must not treat the laws of another Nigerian state as mere facts requiring proof. For instance, an Akwa Ibom State Court is not obliged to demand proof of Delta State law. It is required to recognize such laws automatically. A similar position is taken in England concerning the laws of European Union. EU laws were not treated as foreign laws and therefore did not require proof in English courts. This principle underscores the distinctions between foreign legal system and integrated legal framework within a federation or supranational body. So we'll be going to foreign laws, foreign revenues law in the conflict of law. We said it is an established principle
Before you move to the next one, there is something you should have said.
Okay.
When you noted that sister state laws are not treated as foreign law. There is something you should have said, which is that there is therefore a distinction between the international dimension and interstate dimension of conflict of laws with regard to the requirement for proof. Okay?
Okay,
in
sir.
the case of Benson and Ashiru, the court noted that. The court noted that part of the things that the court of a state is supposed to take judicial notice of include the laws of other states. Okay? Because in that case, the issue was what were the differences between the fatal accident legislation applicable in Western Nigeria and the one applicable in Lagos. And
You have been muted, sir.
Yes, I think Prof is muted.
Hello, sir. Your mic is mute, please.
Goes. The fatal accident pleading requirement is that you must plead the statute if you want remedy under it. And so I think the party pleaded one and not the other. And the Supreme Court observed that it does not matter because it is within the purview of judicial notice what the law of other, what the statutory provisions of other states say. And so once the litigant that pleaded one, even if that one is not the correct position, okay, the court should take judicial notice of what the law of other states says. Okay, so that is the case. That's the case that illustrates what you are trying to point out by referring to those sections of the Evidence Act. At that time, it used to be, I think, Section 73 or so of the Evidence Act. Okay?
Yes, sir.
So let's move on. Let's move on.
Okay, sir. So
There is something you want to say. We may not have time. We may forget.
okay, sir.
What is the implication of not pleading or proving foreign law? The case is one governed by foreign law. That is, the lex concern is the law of another country. But we don't know the law of that country because the party who should benefit from it has not pleaded or proven it. What is the correct approach? What is the correct approach that the court, what should be the correct reaction of the court? Hello?
Yes, sir.
Did you answer that question in your write-up? When a party who should benefit from foreign law fails to plead or to prove it, what should the court do? Hello?
Yes, sir.
Yes, sir. This is Toluwani Florence Ojo. Sir, please, can you hear me, sir?
I'm hearing you. I'm
Yes,
hearing you.
Considering your question, sir, if there's a failure to prove or plead foreign law, the court will
Yes.
court will not apply it to its decisions and conclusions as regards decisions of the forum.
So what will the court do?
Sir?
What will the court do now? Throw away the
Because
case
the
and say, I
court
don't
will
have
assume.
jurisdiction?
No,
Yeah.
no. The court will assume that the foreign law is same.
Yes, that is the correct position. Can you cite authorities for that position? Did you come across any authority?
No, sir.
No, your research is not deep enough. There's at least one Nigerian case. There's at least one Nigerian case.
And Okafor, is it Okafor? No, that one is
No,
accident.
Amanabo and Okafor did not. The judge now, the courts in Amanabo and Okafor did not understand conflict of laws at all. They didn't know what should be done. They thought that the failure to plead or prove foreign law is fatal to a case.
Sir, the case
of Ibanawa and Afocha, the rest of Nigeria.
Now, it did not. Ubawa and Afocha did not talk about anything like that.
Sir, the case of Benson and Ashiru.
Even Benson and Ashiru, the court did not address it directly. The court did not address it directly. I told you people to read my write-up on is it something, Nash law and policy, something like that, where I wrote interstate conflict of tort laws, much ado about nothing. I cited some cases there to show what the proper approach is if foreign law should be the applicable law, but the party who should benefit from foreign law has failed to plead and prove it. The position is correct. The position as the presenter has stated is correct. It is that you would apply forum law on the assumption that the party who should benefit from foreign law did not think that there is any difference between foreign law and forum law. That is why he didn't bother to plead it. Okay?
Okay, sir.
That is the
Yeah.
position, but we should know the cases. We should know the
Case.
cases on that point. So go and read that. I can't remember the cases myself. But let me see, for the English cases, let me check my memories here. But there's a Nigerian case. There's a Nigerian case. I don't know why I keep forgetting that case, but there's also an English authority for that position. I'm very sure I have cited it in this class before.
Is it Agunami and NTC?
No, Agunani and NTC care. Agunani and NTC has nothing to do with that issue. That has nothing to do with that issue. Okay, go on. Before we finish, I will come across the case.
Okay, sir.
Stella, let me take it up from you.
All right.
The second one, this is Olakomi Omoyeni.
Okay.
Good afternoon, everyone. The second one is foreign revenue laws. It is an established principle of the received English law that foreign penal or public law cannot be enforced directly or indirectly by the foreign court. In the realm of conflict of laws, the exclusion of foreign revenue laws emerges as a well-entrenched principle that underscores the territorial sovereignty of states. The English courts, for instance, have long adhered to the position that they will not entertain claims brought by a foreign state to collect its taxes, as epitomized in the seminal decision of Regazzoni versus Setia. The case encapsulates the doctrine that courts do not act as agents for foreign revenue authority, ensuring that the domestic judiciary remains focused on the upholding local laws and principles rather than enforcing fiscal policies of other jurisdictions. Similarly, in Government of India versus Taylor, the refusal to assist in the collection of foreign taxes further solidified this doctrine, emphasizing that revenue laws are territorial and do not extend beyond the borders of the state enacting them. The principle is rooted in the concept of sovereign equality, which mandates that the law of one state, particularly those dealing with revenue generation, are not to be imposed within the jurisdiction of another. This approach protects domestic courts from becoming embroiled in foreign economic disputes and maintains the independence of each state's fiscal policies. However, certain nuances exist within the framework. For example, in Broker versus Setran UK Limited, the involvement of private individuals as creditors alongside revenue authorities posed a unique scenario. Here, the presence of private claims introduced a competing interest that could potentially influence the otherwise strict exclusion of foreign revenue laws. This underscores that the context of this claim and the parties involved may affect the application of this principle, although the general rule remains firmly intact. Another critical aspect of this discussion is the determination of whether a foreign law is revenue based. This determination is not universal, but instead guided by lex fori, the law of the forum, where the case is had. The principle ensures that the domestic court retains control over the classification of foreign laws, applying its own standards and interpretations to decide whether a given law constitutes a revenue law. This reinforces the jurisdictional autonomy of the forum state and provides a mechanism for courts to navigate the complexities of disputes while safeguarding their domestic interests. In practice, the exclusion of foreign revenue laws illustrates the interplay between respect for sovereignty and the need to balance competing interests in cross-border litigations. It serves as a protective measure for domestic courts, allowing them to avoid entanglement in the financial policies and enforcement mechanisms of foreign states At the same time, it reflects a broader reluctance within international legal practice to extend judicial assistance to matters that are primarily the prerogative of foreign sovereigns, particularly in areas as sensitive and localized as revenue locations. The third one, foreign penal law. Foreign penal laws under the conflict of laws present unique challenges due to the interplay between state sovereignty and the nature of penalties imposed. The enforcement of penal laws is tied to the sovereign power of a state, as noted in State of Norway's application number 1 and 2, where it was held that enforcing a foreign penal law could amount to assisting another state in asserting its sovereignty. This principle underscores the reluctance of courts to serve as instruments for enforcing foreign penal sanctions. As such, actions would infringe upon the sovereignty of the foreign state. The rationale was affirmed in Governor of Libya versus Taylor, where the court explicitly stated that a sovereign state would not assist another in asserting its penal sanctions. The determination of whether a foreign law is penal is guided by the foreign law, also known as lex foret. In Hutchinson versus Atrio, the court emphasized that the classification of a foreign law as penal is a matter of the foreign court. This means that the court must analyze the substance and effect of the foreign law rather than merely rely on its characterization under the originating jurisdiction. The courts have established criteria for identifying whether a law is penal, as illustrated in USA versus Inkley, where the US government sought to enforce a judgment from Florida in England. The English court refused enforcement, reasoning that the judgment sought to uphold the criminal law of a foreign state. The court devised a threefold inquiry. If the law primarily benefits a foreign government, it is likely penal. Two, if the law's purpose is to impose criminal sanctions or maintain public order, it is penal. The third one, the broader context, including the remedies sought and their implications, can indicate whether a law is penal. These principles were further expounded in Worms versus Vivaldo, where a French order disqualifying the defendant from managing his affairs was deemed penal and thus enforceable in England. Similarly, in Vicellos Trust and Relangley Settlement Trust, orders relating to incapacity due to health conditions were treated as penalties, emphasizing that such laws could not be imposed by one state within another. A notable application of the exclusion principle is found in AG New Zealand versus Otis, where New Zealand statute prohibited the export of historic articles. When the defendant exported the articles contrary to this law, the New Zealand government sought their recovery in an English court. The court refused to enforce the claim, holding that the prohibition was penal in nature, aimed at protecting New Zealand's cultural heritage and thus unenforceable in a foreign jurisdiction. These cases collectively reinforce the principle that penal laws are deeply rooted in the sovereign authority of a state and not intended to extend beyond its territorial boundaries. The reluctance to enforce such laws ensures that preservation of international community and the autonomy of domestic legal system. That is the third one. I'll leave the fourth one to be done by Oluwani.
I didn't hear you discuss the case of Washington and that tree. Did you mention it?
Yes, I did, sir.
Okay.
Yes,
Because that's the locus classicus on the matter.
Court emphasized that classification of foreign law is penal is a matter of the foreign state. That is the conclusion in Washington and Archie.
But if by the foreign characterization, the foreign law is penal, it ceases to be applicable. Is that not so?
I can't. Yes, sir.
I say if by the forum categorization, the forum law is penal, it ceases then to be applicable.
Applicable, yes, sir.
Okay, before we move to the fourth one, I said I was going to give you authority on the position that if you fail to plead and prove foreign law, it doesn't mean that the court does not have jurisdiction. Nigerian lawyers, we like jurisdiction a lot. Jurisdiction, everything jurisdiction, everything jurisdiction. We have even got to the extent now that We want to look to the Constitution to see whether any court has jurisdiction. And sometimes I ask that a court like the High Court of a state, anything about jurisdiction of the High Court of a state is only contained in one paragraph in the Constitution. What is that paragraph? It says that the jurisdiction of the High Court of a state, to the exclusion of the jurisdiction of exclusive jurisdiction of the Federal High Court, shall be unlimited. That's all. Oh. There's nowhere where you will see somebody list for you what subjects the State High Court can entertain, except that the jurisdiction is unlimited. Yet, in Nigeria, you want to take any matter to court, you will still be searching for which particular court was established for that matter. We are getting to the stage now that even if the legislature makes a law and doesn't have any clause, any provision in that law for the court where you can interpret the law, we say it is no law because it doesn't tell us the court where the matter will be. I think we need to wisen up in our understanding of the word jurisdiction. Everything is jurisdiction. Okay. Listen to what Morris said about pleading and proving. Okay. He said, application of the choice of law rule. Okay. Where do I start the quotation here? He says, after he was talking about it is a general principle of English procedure that in the pleadings, the documents which state the claimant and defendant's position and so identify the issues in dispute, the parties plead only facts and not law. It is for the court, once the facts have been found, to apply the law. And the law means the law which the court knows. That is English law. So prima facie, therefore, even if the facts indicate the presence of foreign elements, the court will apply English law. If either party in that case, if either party wishes the court to apply foreign law, it must say so in the pleadings. In that sense, the possible relevance of foreign law is asserted amongst the pleaded facts rather than argued as a point of law. Okay?
Okay, sir.
Then the implication of this are that the rules of choice of law, that a certain issue is to be governed by a specified foreign law, for example, where the parties were at the time of contract, where the parties were at the time the contract was made, apply only if one or other of the parties choose to raise the point in the pleadings. Application of the choice of law rule is to a striking extent voluntary. By remaining silent, the parties can avoid their application. Okay?
Yes, sir.
So that is the correct position of the law. And the case that Agbede will normally cite for that position, I think is the case of Macmillan Incorporation versus Bishopgate Investment Trust PLC. Okay?
Bishop.
There is also a Nigerian case. I cited that Nigerian case in that my write-up. Okay? So what is the implication? The implication is that any judge who understands conflict of laws cannot throw out a case because it is governed by foreign law. You cannot, in the same vein, you cannot say that because there are no special courts, somebody will lose the right to litigate his dispute simply because the law governing the dispute is not what you would call a local law. If two Jews, I'm saying this because I find the argument about Islamic law very funny, and I've always asked questions that suppose two Jews who are in Nigeria have entered into a relationship governed by Jewish law, and they need to litigate the matter. We don't have a special court. We will not have a special court that will apply Jewish law anyway. So the question of they are going to customary court or area court or Sharia court will not arise. And they come to meet you in your chambers as a lawyer. Are you going to advise them that, no, you can't litigate this in Nigeria because there's no court created specially to handle Jewish law? You would have failed your learning as a conflict expert if you advise that. The fact that the law that will govern their dispute is not local law simply introduces a foreign element. There must be a court in Nigeria that can handle cases where laws that will need to be pleaded and proven can be cited. That court is the state high court. It is the very same court that the Constitution says has unlimited jurisdiction. And not only does the Constitution say it has unlimited jurisdiction, the laws establishing those state high courts also say that they should exercise the same power, the same authority, the same jurisdiction as the High Court of Justice in England will exercise. So today, if two Muslims, whether they are Britons or not, have an issue, and while they are on the territory of England, they want to litigate it, they will go to the High Court of Justice in England, because that is the court that has the power to apply laws that are unknown. Okay? And jurisdiction of courts are not enumerated on the basis of the applicable law. They are enumerated on the basis of subject matter. So I find it funny when we make a lot of money out of molil about dispute governed by Islamic law, and some people will say, oh, because Section 277 of the Constitution has limited the jurisdiction of the Sharia Court of Appeal to certain things. Any two consenting Muslims who enter into a relationship beyond those things, they have no court to approach. I mean, that is elementarily wrong. That is elementary wrong. They have no Sharia court to approach because the jurisdiction of the Sharia court is severely limited. But they have a high court of justice, a state high court of justice, whose jurisdiction is unlimited by its character to go to. Because that is the court that can exercise identical jurisdiction according to its laws with the High Court of Justice in England. And the High Court of Justice in England will not say because the law governing your dispute is unknown to English local laws, therefore you will not have justice. Okay? So it is that same lack of understanding that entered into Amanamba and Okafor case. And you still find people making it all the time. The governing law of a dispute has nothing to do with court jurisdiction. The governing law of a dispute is determined by facts and predetermined connecting factor under conflict of laws. And once the connecting factors direct that foreign law be the law that will govern the matter, then it is for the parties to plead approve that foreign law. It is foreign law because the judge does not know it. It's not what the judge learned in the law school. It is not one of the requirements for appointing him as a judge. So he doesn't know it. But it doesn't mean that I cannot entertain the matter. What it simply means is that that law is fact before it's court. So you will plead it, you will prove it, you prove it by calling expert witnesses, by, if it is a foreign statute, you bring the statute. You don't quote the statute the way you quote Nigerian statute, you bring the statute. If it is a foreign case, you bring the case. You lay it before the court. That's how to prove it. You don't cite it the way a lawyer who is relying on the case to prove law would do. That's the difference. But to say because one particular law, you don't have any particular court, therefore it's not applicable. That is an elementary error. It's an elementary error. I'm telling you, for anybody who understands conflict of laws, there is no law that is not applicable in a country. If the law is not applicable as local law, okay, or existing law under Section 315 of the Constitution, it will be applicable as foreign law. The only difference between the two is that if it is applicable as existing law, the judge is deemed to know it. So you establish it under your address. But if it is applicable as foreign law, the judge is not deemed to know it. You will have to plead it. You have to call witnesses who are experts in foreign law or tender legislation cases from the foreign territory whose law it is that you want to prove. But when you fail to do all of that, the court will not say, you see, like my Lord Justice Oshodi did in one case that I have just read, the president of customary court in Solo and somebody, my Lord Justice Oshodi said that, well, his court is not endowed with ability to apply Islamic law. Therefore, the parties should go to Sharia arbitration panel. Okay? What conflict of laws expect him to do is to say that, look, this is a matter that is governed by Islamic law. In my court, Islamic law is foreign law because I was not appointed as a judge based on my knowledge of Islamic law. But if the parties have pleaded Islamic law on the point in difference, if they had pleaded it and they are called expert witness to prove it, then I would have applied it as a fact. That's the correct position. You do not say that because the law is not known to the judge, therefore the judge does not have jurisdiction. And you do not say because no special court have been created to entertain a law that has peculiarity, therefore the people are disbarred from transacting under that law. That is an elementary mistake. That is, you want to create a situation where the dispute between two Jews and two Muslims, you will not be able to resolve it in Nigeria. Then they will travel to England and go to the High Court of Justice in England, and they have the issue resolved. Whereas your own High Court law tells you that you have the same power as those courts. And everything is there in your evidence law to say that foreign law. Because once you say a law is not your local law, you don't know it. The meaning is that you are treating it as foreign law. That in itself does not mean that the dispute which is governed by that law cannot be entertained. What it simply means is that that law will have to be pleaded and proven. Okay? Hello?
We can
Yeah,
hear you,
yes,
sir.
sir.
Yes, sir.
I hear you, sir.
Okay, so there's another Nigerian case. Go look for it, either in Agbede or in that my article, that established this point, that failure to plead and prove does not mean that you will throw away the case and say there is no jurisdiction. What it simply means is that you apply forum law. So, well, this matter would have been governed by Islamic law, better governed by Islamic law. Islamic law for me as a judge is a law I don't know. So in that way, it is foreign law. If the parties had pleaded and proven Islamic law, I would have applied it. Not pleading or proving Islamic law, I will apply Nigerian law or apply equivalent Nigerian law, something like that. That's the correct position. Okay? So go ahead and discuss public policy.
Yes, sir. Yeah. So, on the part of public policy, we combine it with conflict and conflict justice. So a foreign law will not be enforced if it is fundamentally incompatible with the foreign law's principles of morality, decency, and justice. The concept of public policy and conflict justice are determined by the legal framework of the forum and is applied with careful discretion. The following principles are notable. So I will list out the principles that are associated with public policy. Public policy is context dependent and is flexible. It's very flexible, it does not have any element of rigidity. Public policy is also a defensive mechanism, a common law doctrine despite statutory interventions. That is a common law doctrine despite the several statutory interventions. Then public policy must be involved only in clear violations. There's also caution in public policy application, and also the doctrine is very predictable. So I'll mention some grounds whereby the court would refuse foreign laws on public policy on the ground of the fact that there is a prohibition of interracial marriages, there's divorce restrictions, contracts for sale of slaves. All these are grounds at which the court will not apply foreign laws if these are involved in public policy applications. Also, where there's availabilities of spouses, illegitimacy and maintenance. That illegitimacy and maintenance, I will further talk on it as per laws denying maintenance to illegitimate children upon reaching the age of majority are discriminatory and fail to uphold the best interest of the child. Public policy prioritizes equal treatment and the protection of children, regardless of the circumstances of their birth, making such laws unacceptable. Then the other ground that makes the court refuse or condemn foreign laws can also be on the ground of undue influence and caution, restraints on trade, discriminatory expropriation, fraud and fiduciary breaches, divorce recognition. Yeah. Critics argue that other legal doctrines, such as estoppel, natural justice, and constitutional principles, often achieve the same objectives as public policy. This has led scholars to question the necessity and continued relevance of public policy, given this alternative mechanism for safeguarding justice. So this, as I've pointed out, would make the courts refuse foreign policy when all these are applied in public policy. So I'll move on to public laws. These are another ground at which foreign laws can be excluded. The exclusion of foreign public laws in conflict of laws primarily arises from the principle.
Foreign public laws and foreign penal laws are usually discussed together, but you decided to separate them.
Oh, okay, sir.
Let's go back to public policy.
All right, sir.
Because we won't have time. Let's explain it to ourselves. You know that some things that are freely allowed in some countries, not only are they forbidden in others, they are forbidden with deep passion in other countries. Okay? Take, for example, same-sex marital relationship. At the last count, almost the whole of Europe does not see anything wrong in it. Okay? On the other hand, you have some countries that have exhibited such hatred towards such practice to the extent that it has warranted them to legislate against it. Do you understand? So if a country has a statute forbidding gay or same-sex marriages, if a country has a statute forbidding gay or same-sex marriages, and a couple who had entered into a couple under a same-sex relationship, who have entered into the relationship either, say, in Brazil or Italy or any of those countries where it is permitted, find themselves living in Nigeria, and tomorrow they have an issue. Of all the courts in the world, it is Nigerian court they are approaching to help them enforce their mutual rights under that same-sex relationship. What should the Nigerian court do? Okay, what should the Nigerian court do? Will the Nigerian court say, well, it's not our law, it is Brazilian law that governs the relationship. And so because it is Brazilian law that governs the relationship, and our connecting factor has directed us to Brazil, we will apply it and close our eyes and all of that. Clearly, Nigeria will not do that. A Nigerian judge will come up and say, not in my court. They can have this type of law in Brazil and you can go enforce it in Brazil, but I will not be the one to lend the supporting hand to give effect to this type of law. That's how public policy works. So it is the great dislike of the content and defect of that foreign law that will push the foreign court to say, not in our court. So you see, whereas failure to plead and prove simply means apply our own law, public policy, if a foreign law is so distasteful to us that by our public policy, we do not even wish to respect the foreign country's right to have such laws, then the only thing to be done is to refuse to enforce it and refuse to give effect to the relationship which it has created. So that's the implication of public policy. So you find that in actual effect, what the Nigerian courts will do for pleading and proving, for failure to plead and prove, is what they should do for public policy. It is public policy grant of exclusion that enables a foreign court to indirectly throw away the case. We won't have anything to do with this. But even at that, there is something that Professor Agbede discussed in his textbook. Go and look at it. It's called relativity concept of public policy. It is not always that because the consequence of applying foreign law violates our public policy, it is not always that our decision will be to refuse to enforce it. There are sometimes that you look at the implication of enforcing that foreign law. Maurice and Agbede will give an example. You know that in England, polygamy is contrary to their public policy. But England is a melting point of different nations. And you find people who are coming from countries where polygamy is a norm, certainly in England. So, assuming a couple have married under, say, customary Islamic or whatever law abroad, which law will permit the man to take a second wife? Okay? Now, what does the English court do when it is told to recognize such marriage? Okay? What would the English court do? One option is to say, no, you are not married, though. You are never married. Those of you who did family law, what is that case they normally cite? Is it hide and hide? Hello?
Yes, sir. You are right, sir.
One man
Yes,
and one woman.
for us, it is not marriage if it is not a union of one man and one woman till divorce or death do them apart. So the type of marriage you have gone to which permits your husband or which permits you to take a second wife is not marriage. So you are not married. If the English court had done that, that would have been one way of applying public policy. Okay? But you know what? The man will thank God Almighty and say, thank you, the court of England. He will keep the woman he had come with to England as a concubine and go and marry an English woman in England. Which one promotes polygamy the more? To recognize the marriage and prohibit him from taking a second wife, or to say he's not married, so that you now freely go to the registry and take an English woman who in reality back home will be a second wife. So the English court, they said that the only way to give effect to their hatred of polygamy is to say, yes, you are married, but our recognition of your marriage is that you cannot take a second wife here. So those are the type of examples that text writers will use to illustrate that there is no automatic determination of what a court would do, even when it is clear that a particular position of foreign law is contrary to English public policy. The court will look at the consequence, how the application of that law would affect litigants, vis-a-vis what the English legislature hates to see happen. Okay? The same way that English law says it doesn't like polygamy, polygamous laws are contrary to English public policy. But if you go to England and you say that you are the spouse of a polygamous marriage and you want foreign law entitling you to inherit the man's property, you go to England, the English court would close its eyes to his hatred of polygamy. He will not behave like our courts behave in Fonseca and Passman. He will close his eyes to the hatred of polygamy and give you the relief. He will not say, oh, but this woman she's not even married. She was a second wife under a polygamous marriage. The English court will ignore that. So that is what text writer call relativity of relativity concepts. Relativity concept. That everything will depend on the occasion and the consequence which application of public policy will have on the parties. if applying that foreign law, which is otherwise contrary to English public policy, will produce a more acceptable consequence than not applying it, the English court will apply it. And in doing so, they will not thereby say that they have changed their position, that that law is contrary to their public policy. Okay? So if you have to discuss public policy in an essay, you have to talk about the relativity concept as it relates to public policy. So go on.
Okay, sir. Thank you. So, during the course of our explanation on public policy and conflict justice, we cited some cases. So, we cited Peer International Corporation versus Tamida Publishers Limited. That's what we're talking about, public policy as a defensive mechanism. Then we cited then Kuwait Airways Corporation and
Kuwait Airways.
yeah,
Yes, Kuwait Airways. That's a very popular case.
yes, Iraq.
Iraqi and Kuwaiti Airways, yes.
Yes, sir. Then when we were talking about public policy as an unpredictable doctrine, we cited Boyce versus Chaplin. Then we moved on to citing Scott versus Attorney General. That's when we are talking about the divorce aspect of it, restriction on divorce, on the grounds that foreign laws it can be refused when in the sense of restriction, like there are restrictions when it comes to divorce situations or cases. Then we cited Reeve McCartney when we're talking about
yes.
maintenance. Then we moved on to the discriminatory expropriation, then where we cited Williams Hubert Limited and W&H trademarks. Then we also cited Bank of Tokyo Limited versus Karun when we're talking about fraud, like public policy where there are fraud and fiduciary breaches. That is where there's a deliberate deception or failure to act in good faith by a party entrusted with significant responsibilities. Such acts are fundamentally inconsistent with the principles of equity and integrity. Then we cited Bank of Tokyo Limited versus Karun. Then when we were talking about divorce recognition, foreign divorce laws that deny financial entitlements to a spouse, especially where such denial disproportionately impacts women for the pronunciation, are considered unjust contrary to public policy.
We read your paper.
Right.
Did you cite any Nigerian case?
Yes. No, sir, we didn't cite it here.
There are a number of Nigerian cases that I have come across on the issue. There is one particular case on in those days when we used to have regulations on foreign exchange and what have you. And what happened in the case was that the parties had agreed to what amounted to a breach of Nigerian statute. And the matter came before a Nigerian court. And the Nigerian court says that their agreement cannot be enforced because it will be contrary to Nigerian public policy. If your contract is governed by foreign law, but that contract mandates you to do something in Nigeria that is a violation of the Nigerian law, a Nigerian court will say that the terms of your agreement violate public policy, and we freely accept you're violating it. You're violating that term. Okay? So there's a case like that. Check out what the case. I think that Agbede cited it. There is also the case of, I think, PNOC investment at Hotel Presidential, something like that, which he also cited on a public policy ground. Let's leave public policy. Let's invite a comment.
Okay, sir. Sorry, I just want to go through our recommendations and conclusions, sir. It won't take time.
We will read it. We will read it.
All right, sir.
We will read it. Thank you for the presentation. Any comment before we move to the next topic?
Thank you, sir.
Any comment?
Hello, good afternoon, Prof.
Good afternoon.
Yes, I just wanted to say it was a very brilliant and entertaining presentation. I think they touched most of the salient issues in the topic, and you also provided guidance, as they presented. So it also helped us with the perspective. I have more of like a question regarding the possibility of enforcing otherwise unenforceable foreign law, particularly tax, revenue law. If revenue laws are contained in contracts, for example, terms of revenue payment contained in a contract in Nigeria, is it possible that on the basis of that contract, you enforce indirectly the revenue law, and it will not amount to you enforcing otherwise unenforceable foreign law? Or if
I understand you very well.
Yes.
Maybe the contract is done under foreign law and is taxable by a foreign authority. And there's a provision there for who will pay the tax.
Exactly.
Is that so? If
Yes.
an action is going on in Nigeria, provided the action is between the parties to the contract, provided the action is between the parties to the contract, you will not treat that as a violation of any foreign revenue law. But assuming the contract has been executed and it is somebody who is representing the foreign country that is here or is joined as a party for purpose of recovering that aspect of the payable, then of course the person who is under obligation to make the payment will be able to tell the Nigerian court that you are not established to help foreign countries recover their revenue. So those particular aspects of the relief should be knocked off. Do you understand?
Yes, I understand, Prof. But what I am getting from your answer is that it will be dependent on the party. So
of course, it will be dependent on the party. You see, Mr. A might come to Nigerian court to claim to enforce the contract because he knows that if Mr. B, who is under obligation to pay, does not pay, he will pay over there. Do you understand? But if on the other hand, it is the representative of the country that has come to enforce tax obligation under the contract, of course, Nigerian court will throw the case away and say that we are not here to sit down we are not here to help a foreign country recover its due.
Okay, so it just has to be about the party. So let's say, for example, in England, a court has decided and said that, okay, let's say the tax rate was 5% at the time of the contract, and then the contract contained a variation clause that if the law changes, then the new tax will be payable. And during the contract, it moved to 10%. Now, a court in England has said, okay, that you are bound to pay that money. And let's now assume that it is now, in fact, a judgment of the court in England that is to be enforced in Nigeria. Are you saying that the Revenue Service of Her Majesty, His Majesty in England, cannot enforce that judgment of that in Nigerian court, even though there is now a judgment? They are not bringing it to Nigeria to litigate in this case.
Definitely not. Definitely not. Definitely not. But if the parties had agreed that Mr. A is the person who will pay the variation in tax responsibility. But by English procedure, it is Mr. B that they will charge. Do you understand? And Mr. B sues Mr. A in Nigerian court to enforce the contract. Okay? A Nigerian court would be able to award judgment to Mr. B. Do you understand?
Okay, so it will no longer be in the purview of revenue law. It will now be contract, strictly contract.
Yes, see contract. Because at any rate, he will pay. And his paying is a violation of his contract with Mr. A. So he's only enforcing. If his lawyer couches the relief very well, the tax implication will be very difficult to see. Do you understand?
Yes, sir. Yes, sir. So,
on the other
because
hand, if the UK court are taking Mr. A to court and gotten an English judgment for Mr. A to pay tax, the English court would have to wait until Mr. A has assets in England to pay that tax. The English government or its representative will not be able to come to Nigeria to say A is owing us tax liability. We want to enforce it on his property in Ikoyi. That's not going to be possible.
okay. Because as a matter of research, I was looking at the possibility or avenues of enforcing an otherwise excluded foreign law. If there are ways, there are loopholes within the law that you can apply to enforce those laws, even on the general scale, they are unenforceable. But thank you very much, Prof. Thank you, sir.
Okay. So let's move to the next topic. Or is there any other comments? Group 7, what's your topic? Hello? Are they here?
Yes, sir. Good evening, sir.
What's your topic?
Personal connecting factors.
Okay, domicile, nationality, and habitual residence. Okay? How can you present that in 15, 20 minutes? Oh, okay. Class captain, are they present?
Yes, sir.
Are all the members of that group present?
Yes, sir.
Who is presenting on their behalf? Have they posted their paper on the WhatsApp group? Hello? Have they posted their paper on the WhatsApp group?
Yes, sir, I think we have.
Okay. How many of them are present and who is presenting? Take note of all this because it will form part of the assessment too.
Yes, sir.
Who is presenting on their behalf? Hello?
Hello, good evening, sir. Good evening, sir.
Good evening. Yes.
Yes, sir. So it's actually two of us that are actually supposed to present the paper. So, and the first presenter is actually supposed to take the first part. But in the absence of our presence, I will just proceed.
Who is that first presenter? Class captain, please take note.
Sir, what's the name of the person?
So that we mark him absent.
The person is actually on the call, but I don't know. Maybe the person is not available right now. But I'll just proceed anyway.
Please, thank you. Please proceed.
Proceed.
Okay, all right. So in our paper, we've actually discussed the meaning of connecting factors, history and definition of domicile, and then domicile in Nigeria. Then part 4, we discussed nationality and habitual residence. In part 5, we concluded and gave our recommendations. So moving to the introduction now.
See,
So
we don't have time. We don't
very
have
well.
time. Is there
Very
anywhere
well.
where you define domicile?
Yes, I will just go straight to it.
Yes.
So domicile is actually a foundational concept in the conflict of law, as it refers to a place where a person has their permanent home, or the place which they intend to return. So it is different from mere residence, because residence can be temporary, while domicile implies long-term connection with a specific jurisdiction. And it is usually applicable in cases like divorce, child custody, or inheritance, because it plays pivotal role in deciding which legal systems rules should apply. So now, I will just also move to nationality or citizenship. So it's another key personal connecting factor, and it ties individuals to the legal system of the country which they are nationals. So nationality is also very important when it comes to deciding the rights and obligation of an individual under the laws of his home country. So it plays a central role in issues that are related to inheritance, legal capacity, and family law. We move to habitual residence now. So habitual residence is temporary in nature, and it is different from domicile because of permanence and temporariness of it. So when we look at domicile seems to be permanent in nature, while habitual residence seems to be temporary. So habitual residence refers to the place where a person has is established regular and settled place of living. And in determining that, we have to take into account the frequency, duration, and purpose of his stay in that particular place. An habitual residence is actually useful in cases of child custody and international abduction of children under the Hague Convention on the civil aspect of child abduction. So now going to the meaning of connecting factors. Connecting factors are legal concepts which are used by private international law to link individual or a situation to a particular jurisdiction for the purpose of resolving a legal dispute. So connecting factors can either be personal or local. And the purpose of a connecting factor is actually for the purpose of connecting an individual so that the applicable law that will be used for the determination of his right and obligation will be decided. So now, I will just proceed to chapter 2, because it seems to be a repetition of nationality and every other thing which I've been discussing earlier. So I'll proceed to chapter 2. So chapter 2, we discuss the history and definition of domicile as a connecting factor. So there's no need for me to go through the definition anymore. So there's history of domicile, and the history is actually from the Greek and Roman laws. So the concept as it is applied in Greece law is that every person is subject to the law of his origin, which is actually referred to as lex originis. So the person origo, which is origin, is the yardstick for establishing the connection between the person and the place. So every child took the birthplace of the father or adopted father's origo. Under the Roman law, the concept of Roman domicilium is actually applicable for the purpose of determining domicile. So the Roman domicilium was a bond that binds a person and a specific city. And the resident entity of a city was referred to as an insula, which shows that his domicile is a domicile of that particular city. So unfortunately, a resident who has not displayed the intention to settle in a city indefinitely was not identified as having the Roman domicilium. Okay, so moving to the concept of domicile under English law. The concept of domicile was introduced into the English law in the 17th century, and it refers to a person's permanent home. And under this English common law theory of domicile, the theory of domicile under English law has 3 principles, which are the principle of necessary domicile, principle of unity of domicile, and the domicile determined in accordance with the law of the forum. So with respect to the principle of necessary domicile, it means that a person must have a domicile. There can never be someone without a domicile. And the principle of unity of domicile is each person has one domicile at every point in time. So it's not possible to have two domicile at every point in time. Why the principle of domicile, which is determined in accordance with the law of the forum, the principle seeks to apply English law to determine whether or not a person is domiciled in England. So the importance of domicile is it's serve as a jurisdictional link, which is a prerequisite for assumption of jurisdiction by the forum, or for the recognition and assumption of a foreign court's jurisdiction. It also determines individuals' rights to vote, his right to hold public office, his entitlement to support in respect of various needs such as ill health, unemployment, and his liability to various forms of taxation. All right, the topic of domicile is also important because it is a guide for determining question of personal law. For instance, if you look at the provision of Section 2 of the Matrimonial Causes Act of Nigeria, it provides that before you can commence a divorce proceedings in Nigeria, the petitioner must be domiciled in Nigeria. So we actually rely on the case of Omotunde versus Omotunde. So in that case, the petitioner has been absent from Nigeria and domiciled in United States of America since 1993. And when he brought a petition in 1998 in Nigeria, the court said it's not possible for him to still be domiciled in Nigeria because he has been resident in USA for a period of time, which gives the impression that he's no longer domiciled in Nigeria. So there are 5 principles that govern domicile.
Which court decided that one? Which court decided like that? Hello?
Is the Court of Appeal. Is the Court of Appeal.
Oh, God. Do you know that?
Yes, sir.
I was a consultant to somebody who had a case with wife or concubine, quote and unquote, in England. And evidence showed that since he became a working adult, he had lived in England, and the woman had also lived there. And they have given birth to children living in England who have become, who are in their early 30s. Do you know that an English court said all of that did not meet the requirement of acquisition of a domicile of choice? If the judge had understood the serious requirement to assume that the person had acquired the domicile of choice in another place, they would not with levity have heard that because somebody had lived in abroad for 5, 10, 15 years, therefore he had acquired another domicile. Okay? If that person's domicile was a domicile of choice in Nigeria, a domicile of origin in Nigeria, there are principles, there are rules, and those are the rules. Those rules are the rules that I want you to highlight. Okay? Do you have anywhere in your write-up where you discuss it?
I think I missed the point, sir. I will be happy if you can repeat it. I didn't get everything. I think I had network glitch.
I said that the Nigerian judge who decided that because somebody had lived out of Nigeria for say 5, 10, 15 years, therefore the person had acquired a domicile of choice in the place where he lived, that judge did not understand the concept of domicile very well. You understand? And that I want you to enlighten us about certain rules relating to domicile, especially what we call domicile of origin, and what we call the adhesive character of the domicile of origin.
Yes,
Do you
sir.
have
We've
anywhere where
discussed
we
that.
discuss that?
Yes,
Go
we
to
did.
that.
We discussed that. Yes, I
Let
will
us
just go there.
understand the rules of domicile. Give us the
Very well.
types and rules of domicile.
Very well, sir. So there are 5 principles which are actually applied to domicile. And the first one is that nobody can be without a domicile. So the law assigns a domicile of origin to every person at the time of his birth. So a legitimate child will actually take the domicile of the father, and an illegitimate child the domicile of the mother. And this domicile of origin actually continues until a new domicile of choice is acquired. The second principle is a person cannot have 2 domiciles at a time. While the third principle is domicile connects a person with a single system of territorial law, but it does not necessarily signify a system that prescribes the same principle for all the classes of persons. So we've given an example of India, where different rules were applied to different categories of population according to their religion, race, or caste. So the fourth principle now is there's presumption in favor of the continuance of an existing domicile. And the fifth and final rule is that the domicile of a person is to be determined according to the English and not in accordance with the foreign concept of domicile. So with respect to the lecturer's comment, I will just move to the types of domicile and discuss the domicile of origin. So domicile of origin is the domicile which a person acquires at the point of birth. And the domicile is actually decided by the domicile of the parents of the particular person. And the domicile of origin can never be completely extinguished. So that's one of the very distinctive features of domicile of origin. So when you compare it to other domicile, which are domicile of dependence and domicile of choice, it is hard to lose because it is obvious from the fact that it requires strong evidence to prove its loss, whereas it is less onerous to prove change of other types of domicile. And it has proven to be more tenacious in a way that even if a person leaves his country of origin with an intention never to return back, his domicile of origin survives until he has actually acquired a domicile of choice. So in a situation whereby somebody has left Nigeria and has gone to United States of America, if he has not exhibited any intention that he doesn't want to return to Nigeria again, or exhibiting intention that he wants to settle permanently in the United States of America, it cannot be said that the person has forfeited his Nigerian domicile of origin. So I think the case of Omotunde versus Omotunde was actually incorrect because there's no evidence to show that the petitioner actually made any intention to be domiciled permanently in the United States of America, whether as a domicile of choice. So we've cited the case of Bell versus Kennedy. So Bell is a Jamaican, Bell had a Jamaican domicile of origin, but after leaving Jamaica, it was uncertain whether to settle in Scotland or England. Therefore, the House of Lords held that he had not lost his Jamaican domicile of origin. Also, domicile of origin, another principle relating to domicile of origin is there's a revival capacity for it. So if you decide to acquire a domicile of choice, it is also possible for you to abandon the domicile of choice and revive your domicile of origin. So where domicile of choice is abandoned without acquisition of a new domicile of choice, domicile of origin is revived. And this is founded on the principle that nobody can be without a domicile at any particular point in time. So that's the basis for the rule. So I'll just proceed to discuss domicile of dependence. So the domicile of dependence applies to people who are legally dependent on others, such as children and people that have mental incapacity and also married women. Can you hear me?
I'm hearing you.
Very well, sir.
Go on.
So I said the domicile, very well. The domicile of dependence, it applies to people that children under 21 years old, married women, and people with mental incapacity. So with respect to domicile of choice dependence, with respect to a woman acquires it upon marriage, upon the celebration of a valid marriage, and it can be terminated either by death or divorce of one of the couple. So the principle of domicile of dependence has been subject to a lot of criticism in Nigeria because it is seen as unconstitutional and it is gender discriminatory in nature, because a woman should be able to acquire a domicile of her choice herself without depending on anybody. So in a situation whereby a married woman has to rely on the husband to acquire a domicile of dependence, is anachronistic, and such principle is no longer applicable in foreign countries like England. And I think it's a borrowed principle from England. And as a result of the fact that it was seen as anachronistic in England, it was removed by virtue of the Domicile and Matrimonial Proceedings Act. So there's a case which we've cited, which is Inland Revenue Commissioners versus Duchess of Portland. So in the case, the Duchess who married her husband who had an English domicile, but originally born and had an origin in Quebec. She maintained close links and a house there, hoping to return sometime in the future. She was treated as retaining a domicile of dependence as a domicile of choice, so such that when she left United Kingdom without any intention of returning to reside there indefinitely, on the visit to Quebec in July 1974, she satisfied the requirement as to the cessation of residence in the United Kingdom and so abandoned her domicile of choice. So I will proceed to domicile of choice. So domicile of choice is a domicile which someone acquired, and the person has full capacity, mental and whatever capacity to be able to acquire it. So it is acquired by an individual through physical residence in a new location and the intention to reside there indefinitely. Also, we've discussed the disadvantages and challenges with respect to the law of domicile. I've actually discussed the first one, which is discriminatory and inconsistent and conflicting nature of the domicile of dependence with respect to a married woman with the provision of the Nigerian Constitution relating to discrimination. So the domicile of dependence in Nigeria has been stated not to be applicable in Nigeria. If you look at the case of Afolabi versus Afolabi, the court stated that there are two types of domicile in Nigeria while striking out the domicile of dependence. So I will just quickly go through the case. So the Supreme Court ruled that a Nigerian woman who married a British citizen did not lose her Nigerian domicile of origin, and that her domicile was not dependent on her husband's domicile or on her husband. The court also stated that the principle is discriminatory and inconsistent with the Nigerian Constitution and the African Charter on Human and People's Rights that guarantees the right to freedom of movement, expression, association, and religion. So another challenge with principle of domicile, it is the fact that it is inadequate and irrelevant. So we are in a generation whereby it is possible for you to have transaction with somebody in another country over the over the internet, and as a result of that, requiring somebody to rely on domicile at every point in time seems to be inelegant, let me say. So I will now proceed to.
So I don't understand you. I do not understand you at all.
Very well, sir.
Are you saying that because the internet provides opportunity for people to meet without being located? But that's not, that has nothing to do with domicile.
Well,
that has nothing to do with domicile. We are concerned. See,
yes, sir.
Domicile is relevant because the transactions we are talking about are status transactions. What do you mean by status transaction? Status transactions are transactions where it is not open to the contracting parties to negotiate every clause. The society provides the law, the bulk of the law. How are you? So the society provides the bulk of the law, and the parties just take it or leave it. So what is that law that will govern the relationship is what domicile is all about. So if you like, you go and do the thing in the air.
Yes, sir.
You will be governed by a particular territorial law or a particular personal system of law. And that one will not be dependent on where and when you enter into relationship. So look at most of the issues governed by domicile. A man dies, you want to distribute his estate. You say that the distribution of his estate will depend on the law of his place of domicile. So the place where he dies does not have anything to do with it. If man enters into any contractual relationship that is of the status type. You are saying that there's a law he was carrying with himself wherever he enters into the contract, which will eventually govern the contract. So what has I do not understand what the world becoming a global village, because people can enter into relationship online. I don't know what it has to do with people domicile being remaining a forceful connecting factor, or where a country chooses nationality remaining a connecting factor. I don't understand that your criticism, but maybe when I read your paper, I will get it clearer. Go on.
Very well, sir. So I'll proceed to chapter 3, part 3, which discuss domicile in Nigeria. So the first point here is principle of domicile in Nigeria. So the principle of domicile in Nigeria is actually from the received English law in Nigeria, from the United Kingdom or England. So and it is the basis for determining personal law in Nigeria. And this position has been established in the case of Fonseca versus Passman. And in the case of Osibamowo versus Osibamowo, the court states that there are 3 types of domicile in Nigeria, but if we rely on the earlier mentioned case of Afolabi versus Afolabi, we note that the court has stricken out one of the types of domicile, which is the domicile of dependence. So in that case, we can just agree that there are 2 types of domicile in Nigeria, which is domicile of origin and domicile of choice. Also, in the case of Joanne versus Boani, the court stated that there are strictly 2 types of domicile. So there's no need for me to repeat that since I've discussed it. So now, like I stated earlier on, domicile is used for determining question of personal law in Nigeria, especially when it relates to divorce proceedings. And looking at provision of Section 2 of the Matrimonial Causes Act and the early cited cases of case of Omotunde versus Omotunde, a person has to be resident and domicile in Nigeria at the time of his filing, of his petition for divorce. So if the person is not resident in Nigeria, sorry, I'm confusing resident with domicile. If the person is not domiciled in Nigeria at the point of filing his petition for divorce, the court will actually strike it out, because domicile is the connecting factor for determining the applicable law that will govern the divorce. So now we've also looked at the rules governing domicile in other jurisdictions, and we look at Canada. So in Canada, domicile is
the concept of special domicile for married women.
Sir?
The concept of special domicile for married women for purpose of filing divorce petition.
No, sir, we didn't discuss that.
Okay. Everybody should go and read that one too. Long before the court began to say that there is no domicile of dependency, Nigerian statute actually recognize that there is a domicile of dependency for married women. Our courts now have become lawmakers. They just churn out laws the way they like, using Section 42. One day, they will use Section 42 to say that the customary laws that say that only male children should be kings, they are inconsistent with the Constitution. But they are not applying break at all with this their use of Section 42. To me, it's very, very strange. The idea of making a married woman depend on the domicile of her husband is not meant to reduce her. It's meant to complement her. Equally, the idea of saying that the domicile of an illegitimate child is the domicile of the mother is just meant to appreciate the fact that If a man does not acknowledge paternity or does not marry a woman, then the woman owns the child. But these days of using Section 42 just for any purpose, anything can happen. That's what has happened in those cases where they are saying that domicile of dependence is gone in Nigeria. In 1973, when the Matrimonial Causes Decree was enacted, okay, despite the fact that the Constitution had identical provision to the present Section 42, the legislature did not understand the requirement of married women dependency domicile to be something discriminatory against them. But one of the full implications of the dependency domicile of a married woman is that because most countries will have laws saying that you can only file divorce petition where you are domicile. If a woman's husband has changed domicile, that will be the only place where she can divorce him. And so it is in order to avoid the natural consequence of that rule that the Matrimonial Causes Act had created for married women a special domicile. That special domicile was to permit them to be able, nonetheless, to dissolve their marriage with their runaway husband. And the requirement is that if they were domiciled in Nigeria immediately before their marriage, the understanding means that upon marriage, they lose their domicile, their separate domicile of origin. 2, if the husband was, if they were domiciled in Nigeria before they were deserted by their husband. And 3, if they had lived in Nigeria for the last 3 years. So in all of these 3 circumstances, the Matrimonial Causes Act permits them, notwithstanding that by virtue of the concept of domicile of dependency, they have lost their Nigerian domicile. Nevertheless, they will be able to file a petition for divorce. Now, all those provisions, they will go for nothing because our courts are willing to use Section 42 to just stop everything. See, so the concept of domicile of dependency is no longer correct because of our new laws for spur of the moment construction of Section 42. Okay? So if the court now say there is no concept of domicile of dependency, the meaning is that the idea of creating a special domicile has outlived its usefulness. Okay?
Very
Well,
well,
I think one day somebody will present a comprehensive argument to say that there's a limit to which you can use Section 42 to dismember the body of laws in the area of status. Okay?
Very well, sir.
So now talk briefly about habitual residence and nationality and compare them with domicile.
Very well, sir. So we discussed the role of nationality and habitual residence in part 4 of the paper. So in Nigeria, nationality is an important connecting factor that determines an individual's legal relationship with the country. And nationality, which is actually also referred to as citizenship, is regulated by Nigerian Constitution and various international agreements to which the country is a signatory. So nationality and citizenship are not actually the same, but when we look at it from the realm of Commonwealth countries, it is used interchangeably.
Let me guide you. You are not in public international law, you are in private international law. You have started by telling us that what we use as connecting factors in the area of personal law is domicile. You are absolutely correct on that. Okay? We don't use nationality. Okay? So it will never
Yes,
be
sir.
an issue whose country's national you are for purpose of determining the law that will govern you in the area of personal status. What will be an issue in Nigerian court is where are you domiciled? Do you understand? But we are surrounded
Yes,
by
sir.
countries that use nationality. Most civil law countries, they use nationality. Okay?
Yes, sir.
Most
Yes,
of the
sir.
continent of Europe, with the exception of England, they use
Yes.
nationality. Okay? So when a country uses nationality as connecting factor, the meaning is that where the propositors is a domicile of state Y, but a national of state X, in the court of that country, it is the law of state X whose national is that they will apply. Whereas, if it is in Nigeria, it is the law of state Y where is domicile that we will apply. That's the implication. The countries of the world are divided among those who use domicile, those who use nationality, and a few whose interpretation of domicile is habitual residence. So if a country uses nationality as connecting factor and the propositors is domicile elsewhere, that country's court will ignore the domicile and apply the law of the country whose nationality is. That's the implication. So for academic purpose, we want you to compare. Can you compare nationality with domicile?
So we've not actually done the comparison in our work anyway, but just
That's the
going
what you
through
are
the
doing. You are in the comparative conflict of law class. The case is going on in Nigeria. If
yes,
the
sir.
case were to go on in Benin Republic, where nationality is what the court will use, what is the difference? Which is better? That's the type of thing we want you to educate us on. Okay? Go and read. Everybody in the class, go and read. But the summary of it all is usually provided by text writer. They will tell you that if you are looking for a connecting factor that is easy or certain to determine, go for nationality. If you are looking for a connecting factor that is appropriate, go for domicile. And what do they mean by that? The English text writers want us to believe that domicile is more appropriate because it links you with a law that you are familiar with. Okay? The fact that domicile permits you to acquire a domicile of choice is an attempt to connect you with the law that you are familiar with, to govern your affair with a law that you are familiar with. Whereas nationality, according to them, has the possibility of linking you with a country whose law you don't know, a country whose territory you probably have never visited, but whose national you will remain by virtue of the circumstances of birth. Okay? So, but on the other hand, the text will tell you that whereas domicile is more appropriate, it is difficult to determine. The original idea about domicile is that it is your home. But when you now look at the rules, you will see that many homes that you have will not qualify as your domicile. Many places that you have stayed all through your life may not qualify as your domicile because of the tests. The courts find it difficult to accept that you have freed yourself from your attachment to your domicile of origin. And so it is usually very difficult to determine the domicile of an international person who has lived in different countries for a given number of years. And the case is made worse by the fact that domicile is not exactly habitual residence. because there's a mental element required for you to acquire domicile of choice. Animus D. Okay, you must have an intention of indefinite residence. And so usually, most of the time when domicile become an issue, especially in succession matter, it is after the death of someone. So you have to read the man's entire biography, his entire life, his wishes, what he hated, his habits, his likes, his dislikes, to be able to say, this is the place we can really call the domicile of this person. And when you now fail that, you go back to square one, which is what was the domicile of his parents. And then you attach the same domicile of origin to him, which he had from birth. And yet, you say domicile is appropriate. Nationality is not appropriate. What is the difference between the two of them? Both of them can end up attaching you to a law you don't know about. Even the concept of tenacity of domicile of origin has as much problem as the concept of nationality. Then when you talk about ease of determination, it is usually a question of fact, whose national a person is. Okay? But there could be problem because there are people who have double nationality. How do you determine the law that will govern the life of a person with double nationality? Somebody who is domicile, who is a national of Nigeria and UK, or a national of Nigeria and the US. Which law are you going to apply to him? Okay? Whereas
Yes,
domicile has a rule that you cannot have more than one domicile, at least for the same purpose, at the same time. So go and read any basic textbook for a comparison between domicile as connecting factor and nationality as connecting factor. Look, gentlemen, on that note, let me go and break my fast. Somebody is suggesting that we should meet on Saturday. We have at least one more topic that we want to take. Marriage and matrimonial courses. What I'm going to do is I'm going to go through. I'm going to go through whatever group weight I've presented. Did you break marriage into two, or is it only one group that treated all of it? Hello? Hello? People have gone.
Hello, sir.
Yeah, yes, sir.
Yes,
I
I
said,
hear
did
you,
you
sir.
people
This
break
group
marriage
8
into
members.
two? Did you
Group
break
8
it into
members
two?
want to answer that, sir.
You did what?
Group 8 should be one they want to answer that, sir. We didn't have the idea.
Yes, good evening, Prof.
Okay.
Good evening, Prof.
Good evening.
Good evening to my colleagues. Group 8 is just one group. It's just one topic for the entire group 8.
Marriage is a long topic. Okay. We'll discuss. You said, when did you people say we should meet? Let me look at, between now and tomorrow, I'll look at my program and see whether I can attend that Saturday lecture. If I attend it, however, we will round up on that day and go and prepare for exam. If I don't attend it, we will round up on Wednesday. So I will let you know if I will be in a position to attend it.
Okay, sir.
So see
Thank you,
you.
sir. All
See
right.
you
Thank you,
on
sir.
Saturday. If we are doing it on Saturday, we will be doing it between, say, 12 and 2. Is that all right?
It's fine, sir. It's fine, Prof.
Okay. see that?
tí kò sí nepa wọ́n lò láì wọ́n ní fáànù fẹ́ ṣe pé òun ló pa kinní kò kú
Ó kà kí ni?
òun ló pa ìbátan pé kò lè kú.
Ta ló sọ bẹ́ẹ̀?
Sọ sí
Wọ́n mọ nǹkan dáhùn. Àwọn tí ń lò látàárọ̀.
wọ́n ní fáànù yẹn because kí ni ẹ̀ ń kú ó tọ̀ lẹ́ẹ̀kan nígbà tí mo dé bí.
Ó ń kú ọ̀ǹtà ní ilé náà, ilé ògbé máa nì.
wọ́n ní fáànù yẹn ò kú wọ́n fẹ́ pa fáànù náà nípa.
Wọ́n á rí pa.
That's what she said.
Àwọn ò ti pa nígbà tí ẹni tó máa bí tẹ̀ wọ́n.
Bisola, bring it now.
Ish.